This video captures a tense and confrontational courtroom exchange between Judge Perkins and a sovereign citizen defendant who appears after missing a prior Zoom hearing. From the outset, the atmosphere is strained, as the defendant immediately challenges the court's authority and attempts to assert constitutional arguments in an effort to dismiss the case. As the hearing progresses, the defendant becomes increasingly argumentative, interrupting the judge and demanding explanations while refusing to follow proper courtroom procedure. Despite the disruptions, Judge Perkins remains calm and focused, clearly explaining the legal process and maintaining control over the proceedings. The situation highlights the ongoing challenge courts face when dealing with individuals who rely on sovereign citizen ideologies, often using confusing legal jargon to resist authority. Ultimately, the video provides a compelling look at how patience, professionalism, and firm courtroom management are essential to keeping the justice system on track, even in the face of persistent disruption.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case until you get the chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only like 3 paragraphs, the entire thing. The rest are just case sightings.
All right, I'm gonna deny the motion. I will set the matter for.
Is there any way I can get a written? Can I get a written articulation as to why you're denying the motion?
I'm denying the motion because
I would just appreciate a written excuse. Can I get a written articulation?
I might give it to you in writing.
Are we on record? Are we on record?
We're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Yes.
Okay, you were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking for a change of venue. I'm denying.
I'm saying that I know there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
Okay, I'm denying a motion to dismiss. Okay, I'll set a trial date for you so you can be heard on that type of forum.
I insist that the court give me a written excuse as to why you're denying my motion, so I could take that to the tenor. Okay.
Well, you can insist all you want to.
Okay, I appreciate that, but I'm telling you, you're telling me today why you're not going to look into it or give me a hearing, that's so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that, so I'm just asking that you can give me a written excuse that I could go take and complain against you on, because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there. Y'all suspect me for no crime. There's no victim, no losses. Okay. And in a minute, it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you. Because if not, I'm going to go to the tenor without it and let them know that you refuse to give me a written excuse, and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. Because you're Article 1 judge under the Commerce Clause. This conflict of interest, you only here to make money, man. You know what I'm saying? It ain't no crime.
Ain't
no victim or no loss, bro.
Listen, I'm not your man.
Look, sir. Hey, sir, respectfully, you're an Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to somebody. I'm asking you to give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence or change venue. Because if not, I'm going straight to the tenor right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, that's all we need. I don't want to hear any more.
All right, cool. It's cool. I appreciate it. This due process violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They're
Mr.
not
Lewis.
prepared to present a case. I'm telling you. They're
Mr.
not prepared
Harris,
to present an
Mr.
injured party.
Rico,
So
he
what we
doesn't want
doing?
to be represented. Listen. Please do not say any more. You've already made your record. I've given you that opportunity. If you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You
Okay,
take
let's do
whatever.
price to tenor.
Wait a minute. Let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have an opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your.
As the hearing comes to a close, it becomes clear that despite the defendant's repeated interruptions and attempts to challenge the court's authority, the legal process remains firmly on track. Judge Perkins maintains control throughout, ensuring that the case proceeds according to established rules and procedures. The defendant's arguments, rooted in sovereign citizen beliefs, ultimately fail to influence the direction of the case. This moment highlights an important reality of the justice system. While individuals may try to disrupt proceedings or question legitimacy, the court relies on structure, patience, and consistency to uphold the law. The judge's calm and measured response serves as a reminder that professionalism is key in maintaining order, even in the face of persistent defiance. In the end, the outcome reinforces that the courtroom is governed by legal standards, not personal interpretations of the law. No matter how intense or confrontational the exchange becomes, the process continues forward, ensuring that justice is handled through proper channels and not derailed by disruptive behavior.